Hello ladies and gentlemen, this is Attorney Parole and we are going to discuss about H1B and pending EAD through adjustment of status. As you know, when you're on H1B, you are eligible, it's a dual intent visa, so you can have a green card filed together with that. And while the green card is filed, the adjustment of status is filed, you are eligible for a work permit, which we call the EAD, Employment Authorization Document for short. It's EAD. So what happens before, when people will call me, they say, hey, I have the H1B, I have the EAD, which one should pick, which one should I use? I used to tell them there's no purpose to really keep the H1B unless it's necessary for maybe your spouse doesn't have an EAD, then you can go for H4, etc. But now my position has changed. The reason I changed is that this famous memo of June 29, 2018, where people are going to be placed in deportation and denial. What happens is that if you have the EAD and the H1 and you are placed in deportation, if your I-45, which is the adjustment of status, is denied and you won't be placed in deportation if your H1 is active. How do you get the H1 active? Just having the 797 doesn't count as active. For example, let's say you travel abroad and you came back and you advanced parole, which is given usually with the adjustment of status, the AP, you are not on H1B status, okay? You're in what we call a period of stay authorized by the Attorney General under INA 245A. What it does, it allows you to stay legally, but you're not in status. In order for the status to kick in, you have to travel outside on the H1B and come back, then the H1B will kick in. However, if you maintain the H1B from the beginning, it won't, you're still on H1B. This is only in situation people who have shifted to EAD and they have not used the H1B. So bottom line, my advice today, my recommendation is to keep that H1B alive as much as you can, in case, especially if you have some kind of criminal convictions that can come into play. For example, a criminal conviction now can result in a denial of I-45, although they should not be doing this, they might do it. And by the time you fight it, if you don't have a status, you might end up in front of a judge through the NTA memo and have to fight your case there, which is really hard, because not only it's hard, it's costly, it takes a lot of time. So in order to avoid this problem, for those who have H1B and EAD, and they can maintain the H1B, I recommend maintaining the H1B. If you cannot, that's fine, but I'm recommending people who can, go ahead, keep your H1B, and for your spouse, the same thing, keep the H4. So this was just a quick video kind of to cover this topic, because I'm getting a lot of questions relating to that. So I highly recommend that you contact an attorney if you have any questions. We are a law firm. You can contact us 510-7425-887. Anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Thank you.